states which constitutional regime applies to the transition period in question. He referred the court to Section 2 of the Act, which provides that the applicable constitutional regime referred to in Section 7 is the repealed Article 35 of the Constitution. Section 2 of the Act provides as follows. Constitution means the Constitution of Zambia, 1991, in force immediately before the effective date. It was further argued on behalf of the petitioner that the transitional clauses do not provide for the retroactive application of the Constitution. He submitted that Sections 2 and 7 of the Act clearly identify the applicable Constitution to the first respondent's first term. With regard to Article 106 of the Constitution, it was a petitioner's submission that since Sections 2 and 7 of the Act ensured that the repealed Article 35 of the Constitution applied to the first respondent's first presidential term, it follows that the second presidential term was subject to Article 106 of the Constitution. Counsel submitted that the first respondent served his first presidential term from 25th January 2015 to 13th September 2016, which was considered a full term as per the repealed Article 35 of the Constitution. That the first respondent thereafter served the second presidential term from 13th September 2016 to August 2021 under Article 106 of the Constitution, and he cannot consequently serve a third presidential term, as that would be unconstitutional. Counsel further argued that the consequence of this was also that the first respondent, in effect, contravened the Constitution through his nomination and participation in the 2021 elections. With regard to the principle of per incuriam, it was submitted that, as a general rule, per incuriam generally refers to a judgment rendered in ignorance or forgetfulness of a relevant statute, provision, or other authority binding on the court. That in these circumstances, the court is tasked with correcting these errors through the principle of per incuriam. The petitioner referred the court to the case of Haja Import and Export Limited versus Zambia Revenue Authority, in which the Supreme Court held that it is a well-established principle that this court is bound by its decisions except where there are two conflicting decisions or where a previous decision was per incuriam. It was argued that the Legal Resources Foundation case was rendered per incuriam as the court omitted to read Section 2 with Section 7 of the Act, which requires that the repealed Article 35 of the Constitution be applied to the first respondent's first presidential term. Counsel argued on the basis of the above submission that the court should depart from the majority decision in the Legal Resources Foundation case. With regard to the first respondent's argument that the action before this court is res judicata, this court, having previously pronounced itself 3 times on the same matter, specifically in the cases of Daniel Pule and others versus Attorney General and others, Bambi Aubrey Kapalasa and another versus the Attorney General, and Legal Resources Foundation, the petitioner opposed this claim as there was a clear distinction between this matter and the 3 above stated previous cases. He argued that whereas the previous cases were mainly focused on Article 106 sub-Article 3 of the Constitution, the present case is about the interpretation of Section 2 and 7 of the Act, as read with the repealed Article 35 of the Constitution. He noted that whereas the doctrine of res judicata prevents a party from relitigating a matter that has already been resolved by a court of competent jurisdiction, the rationale being to promote finality of judgments, conserving judicial resources, and protecting litigants from vexatious litigation. This doctrine was inapplicable in the present case. He also referred this court to the Supreme Court decision in Hussein Safiuddin versus the Commissioner of Lands and others, which laid down three essential elements of res judicata as follows. Firstly, there must be an earlier decision on the issue. Secondly, there must be a final judgment on the issue. And thirdly, there must be an involvement of the same parties or parties in privity with the original parties in the same cause. The petitioner argued that this matter bears a clear difference with the previous cases, as the petitioner was not a party to the previous cases. He, on this basis, argued that the matter cannot therefore be deemed res judicata. He further argued that the doctrine of res judicata is not an absolute principle, as there are several exceptions to its application. He listed the exceptions as lack of jurisdiction, the presence of fraud or collusion, material changes in the law or facts, and mistake or per incuriam, where a judgment was based on a mistake or omission of relevant facts or law, rendering it potentially worth review. With regard to the claim of abuse of court process by the first respondent, the petitioner referred this court to Order 88/19 of the Supreme Court Rules of England, the White Book, and the cases of Chickmasters Limited and another versus Investrust Bank PLC and Zambezi Portland Cement Limited versus Stanbic Bank Zambia Limited, and submitted that in the case at hand, the petitioner had not relitigated the matter, and this case does not amount to abuse of court process. On the claim by the first respondent that this court is in this matter functus officio, the petitioner referred the court to Housebury's Laws of England, which defines functus officio as an instance where justice or indeed the court has discharged all its judicial functions in a case. He also referred the court to the case of Ituna Partners versus Zambia Open University Limited, where the Supreme Court held inter alia that a court becomes functus officio when all the substantive issues in the cause are determined by it. If such matters are not determined by the court, like in the case of Jackie Lungu, then the court is not functus officio. Based on the above authorities, counsel submitted that the court did not rule on the issues raised in this matter, and more importantly, that the functus officio argument only applies where an issue is sought to be raised in the same action where a court has already rendered a final judgment, which is not the case in this matter. With regard to the first respondent's submission that the petition is out of time and that the court lacks jurisdiction to hear the matter, the petitioner submitted that this petition is not premised on Articles 101, Subarticle 4 to 7 of the Constitution, as he is not disputing the eligibility of the winning presidential candidate, and neither is he disputing the election of a president, nor the nullification of the outcome of the presidential election. In oral augmenting his written submissions, the petitioner's counsel submitted that the court was essentially being asked to interpret the meaning and effect of Section 7 and 2 of the Act, and whether a combined reading of the two provisions does not preserve the first respondent's first presidential term under the repealed Article 35 of the Constitution. He further submitted that the first respondent did not qualify to participate in the 2021 presidential election, and neither does he qualify to participate in any future presidential election in Zambia under the Constitution. This, he argued, was because he has served 2 full terms and will be in violation of the Constitution if he attempted to seek a 3rd term. It was argued that to attempt to apply Article 106 of the Constitution to the first respondent's first presidential term would be unconstitutional, as it has no retrospective effect. He referred the court to the Supreme Court decision in the case of Martin Nyambe versus the Attorney General, in which it held that laws have no retrospective effect unless the amendments explicitly so provide. With regard to the plea of res judicata, counsel submitted that the reliefs that he seeks in this matter are different from the matters that have previously been before this court. He further stated that the petitioner has never been a party to any previous proceedings before this court. Counsel argued that there can be no res judicata in a matter where a party argues that a judgment has been delivered in ignorance or forgetfulness or omission of an important provision of the law. With regard to the first respondent's argument that the court is functus officio, counsel reiterated the court can only be functus officio in a matter it had heard on its merits and rendered a final judgment, noting that this matter had just commenced. That this matter cannot therefore be said to be functus officio, and neither can it be argued that the proceedings are an abuse of court process, as the petitioner is not relitigating. First respondent's case. The first respondent filed an answer to the petition and affidavit verifying answer, both dated 17th November 2023. The affidavit verifying answer was sworn by Edgar Chagwa Lungu, in which he succinctly averred that he would rely on the contents of the answer. He also relied on affidavit in support of notice of motion for determination of questions of law and skeleton arguments in support of the notice of motion for determination of questions of law, both dated 30th November 2023. In his answer to the petition, the first respondent contended that this court had already pronounced itself on the issues being raised by the petition and that he had not served 2 terms. He further stated that this court had thoroughly reviewed all legal provisions, including the repealed Article 35 of the Constitution, and that the majority decision was not made in ignorance of any applicable law. He finally urged this court to embrace the principle of finality in legal decisions, considering the potential adverse consequences of setting aside a decision that was rightfully made in his favor. The affidavit verifying answer repeated the contents of the answer. The first respondent's case was further supported by skeleton arguments. Therein, and with regard to the doctrine of res judicata, the court was referred to the cases of Chickmasters Limited and Hussein Safiedin, in which the Supreme Court held that the objective of the doctrine of res judicata was to discourage relitigation of the same issues definitively settled by judicial decision, except by means of an appeal. It was argued that the issues raised in the petition, that is the interpretation or consideration of Article 106, Sub-Article 3 of the Constitution, and the determination of the first respondent's eligibility to stand as a presidential candidate in 2021, had already been settled by judicial decision or judgment. With regard to the issue of involvement of same parties or parties in privity, the court was referred to the English case of Gleason versus J. Whipper, in which it was held that the requisite privity is said to be a privity either of blood, of title, or of interest. It was argued in this respect that the petitioner shares a similar interest with the petitioners in the 3 previously decided cases of Daniel Pule, Bambi Kapalasa, and Legal Resources Foundation. It It was further argued that the similarity arises from this petition's foundation on the first respondent's eligibility and seeking the interpretation of Article 106, Sub-Article 3 of the Constitution, among other pertinent matters. It was also submitted that this court, having interpreted Article 106, Sub-Article 3 of the Constitution, in the said three previously decided cases, lacks jurisdiction to hear and determine this petition, as it has become functus officio. It was further submitted that since the current petition seeks to indirectly challenge or involves the presidential election of 2021, the process for challenging election results as per Article 101, Sub-Article 4A and B of the Constitution should have been followed and pursued within the designated time frame and process. The first respondent further argued that the challenge regarding the 2021 election or his eligibility to run in those presidential elections, based on the claim that he had previously held the presidential office twice, should have been brought forth following the prescribed procedure. That reopening this issue through a separate petition is legally unsound and exceeds the court's jurisdiction. In orally augmenting the written submissions, the first respondent submitted that the petition is incompetent on the ground that it challenges his nomination as a presidential candidate in the 2021 elections, as well as his candidates in the same elections. He argued that this court has no jurisdiction to entertain this petition, as Article 52, Sub-Article 4 of the Constitution provides that a challenge to the nomination of a candidate may only be made within 7 days of the close of nomination. That the nomination for the 2021 elections were held more than 3 years ago, and an attempt to challenge this nomination at this late stage is misconceived. With regard to the presidential election, it was submitted that Article 103 of the Constitution provides a mechanism for the challenge of the election of a president-elect. It was further submitted that what was before the court was unique, as the petitioner has petitioned a losing candidate, noting that there is no provision in the Constitution for the challenge of a losing candidate, and the petition was to that extent misconceived. It was also submitted that the provisions of the repealed Article 35 of the Constitution, Section 7 and Section 2 of the Act, were considered in the Legal Resources Foundation case in the dissenting judgment, and that the court was therefore aware of these provisions. Further, that the doctrine of per incuriam does not therefore apply. With regard to the doctrine of res judicata, it was argued that the issue before the court had already been dealt with 3 times, and the doctrine of issue estoppel and cause of action estoppel therefore apply. It was further argued that in a matter such as this, a court has come to the final conclusion, having heard the matter on its merits, there is nothing further that can be done. It was finally submitted that the mode of requesting this court to review its own decision is wrong, and the court should therefore not entertain this matter. In this respect, the court was referred to the English case of Taylor and another versus Lawrence and another. The second respondent's case. The second respondent filed an answer to the petition, affidavit in support of answer to the petition, and skeleton arguments, all dated 16th November 2023. It also relied on its affidavit in opposition to notice of motion for determination of questions of law and skeleton arguments in support of affidavit in opposition to notice of motion for determination of questions of law, both dated 19th December 2023. In its answer to the petition, the second respondent submitted that in the performance of its functions, it is guided by relevant electoral laws, including the Constitution, the Electoral Process Act No. 35 of 2016, and the Electoral Commission of Zambia Act No. 25 of 2016, and the regulations promulgated under these laws. It was submitted that the Constitution obliges the second respondent to either accept or reject nomination papers filed by a candidate wishing to contest presidential elections. It was further submitted that it abided by all the requisite laws for processing the nominations for the presidential elections, for the presidential candidates. The affidavit in support of the second respondent's answer, signed by Mr. Brown Casaro, the Chief Electoral Officer, essentially repeated the contents of the answer. The second respondent's case was further supported by skeleton arguments in which it was submitted that it did not breach the Constitution when it accepted the nomination of the first respondent, as it followed all the electoral laws related to the nomination referred to in this petition. The court was referred to the case of Bizwayo Nkunika versus Lawrence Nyirenda and the Electoral Commission of Zambia, in which we guided on the mandate of the second respondent in relation to Article 52, Sub-Article 2 of the Constitution, that the second respondent's mandate was to either outrightly accept or reject the nomination based on the qualifications submitted by the candidate. The court was also referred to the case of Charles Maboshe versus Stephen Nyirenda, Luce Changwe, and the Electoral Commission of Zambia, in which this court guided on the steps for challenging a nomination filed in accordance with Article 52 of the Constitution. It was finally submitted that the nominations for the 2021 general elections conducted from 17th May 2021 to 20th May 2021 were conducted in accordance with the requisite laws and did not breach any provisions of the law during that process. At the hearing, the second respondent relied entirely on its written submissions. Third respondent's case. The third respondent filed an answer to the petition, affidavit in opposition, and skeleton arguments on 16th November 2024. The third respondent also relied on the affidavit in opposition to the first respondent's notice of motion for determination of questions of law and skeleton arguments in opposition to the first respondent's notice of motion for determination of questions of law, both dated 19th December 2023. In his affidavit to the petition, the third respondent contended that this court should vacate its decision in the Legal Resources Foundation case, as Article 106 of the Constitution does not operate retrospectively. The affidavit in opposition, signed by the Attorney General, Mr. Mulilo Dimas Kabesha, essentially repeated the contents of the answer. In his skeleton arguments, the third respondent submitted that the first step in construing or interpreting the law is the literal rule, and referred the court to the Black's Law Dictionary at page 45, which defines the literal rule as interpretation according to the narrowest, most literal meaning of the words, without regard for context. The court was also referred to the cases of Attorney General and another versus Lewanika and others, and Stephen Katuka, which essentially adopted this principle as a primary principle in interpreting the Constitution, unless it leads to absurdity when other principles of interpretation may be resorted to. It was argued that had the court taken into consideration sections 2, 6, and 7 of the Act, as read together with the repealed Article 35 of the Constitution, it would not have arrived at its decision in the previous cases of Daniel Pule, Bambi Kapalas, and the Legal Resources Foundation. It was the third respondent's argument that in line with literal interpretation of statutes, the first respondent's presidential term between 25th January 2015 to 13th September 2016 was governed by the repealed Article 35 of the Constitution. With regard to the doctrine of per incuriam, it was submitted that this doctrine is an exception to the legal principle of stare decisis. The court was thus requested to declare its judgment in the Daniel Pule case per incuriam, as it was arrived at without considering other relevant pieces of law, namely sections 2, 6, and 7 of the Act. It was further submitted that the court, in fact, wrongly applied Article 106 of the Constitution in interpreting the first respondent's first term of office of President, as the said Article 106 did not have retrospective effect. The case of Zambia Consolidated Copper Mines Limited versus Jackson Munyika, Siame, and 33 others was cited in support of this contention. The third respondent also submitted that he agreed with the first respondent's reliance on the case of Hussein Safieddin, which laid down the 3 grounds to succeed in the defense of res judicata. He, however, denied that the matters in this petition are res judicata on the basis that the petitioner was neither a party to the 3 previous decisions referred to by the first respondent, nor was he privy to the parties therein. It was further argued that even though the issue of eligibility is raised in this petition, it is from a very different constitutional perspective, one that was not considered in the previous cases, and that as such, this petition deserved to be heard on its merit. With regard to the issue of whether this court can depart from its previous decisions, it was submitted that this court, being the apex court in constitutional matters, has the jurisdiction to review and overrule its previous decisions. In support of this submission, reliance was put in the case of March Corporation Limited and the Development Bank of Zambia versus the Attorney General. The third respondent also submitted that this petition, based on the arguments above, is not an abuse of court process, that the petitioner and his advocates were neither parties nor involved in the previous decisions of the court referred to by the petitioner. It was argued that the matters herein are not the same as those that were the subject of the said previous decisions. With regard to the constitutional concept of mandatory alternation, it was submitted that at the core of it, the concept entails the democratic political power must be limited by only allowing a person to hold office of president for a determined period, and after that, a different person must be elected. That in Zambia, Article 106, Subarticle 3 of the Constitution is the hallmark of the concept of mandatory alternation. It was further submitted that the said Article 106, Subarticle 3 of the Constitution provides that a person who has twice held the office of president is not eligible for election as president, and that the meaning of that provision is that a person is only allowed by the Constitution to hold the office of president twice, or in other words, a person can only be sworn into office as president twice, and no more than that. It was also submitted that the Constitution was largely based on the combination of the findings of the Mungomba, Manakatwe, and Muvunga Constitutional Review Commissions, and that the will of the people, as referred to in the 3 commissions' reports, is unequivocal in that they wanted the office of the president to have a limited tenure attached to it. That the will of the people was reflected in the National Constitutional Conference's initial report. With regard to the argument put forward by the first respondent that this petition is incompetent as it has allegedly been brought outside the time frame for challenging the validity of an election and candidates of a presidential candidate, it was submitted that nothing stops this court from inquiring into an alleged contravention of the Constitution. This, it was argued, was notwithstanding the time frame provided for to challenge the validity of an election and candidates of a presidential candidate under Article 101 of the Constitution. In support of this submission, the court was referred to the decision of this court in the case of Wizwayo Nkunika versus Lawrence Nyirenda and the Electoral Commission of Zambia. In orally augmenting the submissions, the third respondent submitted that in the class of eligibility cases, this petition is sui generis. That is the first, that it is the first of its kind in the jurisprudential history of the Constitutional Court, in that it has brought in an angle which has never been determined by this court, and that is to contextualize the effect of Sections 2 of the Act, Section 2 of the Act as read with the transitional provisions in Section 7 of the said Act. Further, that ultimately it is asking this court to look at the effect of the repealed Article 35 of the Constitution on the first respondent's first presidential term. It was argued that the court in the Daniel Pule, Bampi Kapalasa, and Legal Resources Foundation cases did not pay particular attention to, nor did it take into consideration Section 2 of the Act, which defines the operative constitution, which applied on the effective date of the 2016 amendments to the Constitution. That the Daniel Pule case in its entirety was purely centered on Article 106 of the Constitution, and there was no contextualizing in all these cases the effect of Section 2 of the Act. Hence, the court ended up making wrong inferences that the framers of the Constitution did not provide for transitional provisions relating to the first respondent's first presidential term. It was submitted that there was no need to provide for a transitional provision in Section 7 of the Act, because the issue at hand was catered for in Section 2 of the Act. Further, that the repealed Article 35 of the Constitution is very clear in that it provides for twice elected and not holding office. It was further submitted that ultimately, whether this issue has been pleaded or not, the court is being called upon to invoke the per incuriam rule, as the court had already decided on that issue, and it is being asked whether to sustain its decision in the Legal Resources Foundation case or not. On the issue of jurisdiction of this court to review its decision, the third respondent referred the court to the Kenyan Authority of Interim Independent Electoral Commission, in which the court held that its jurisdiction is clothed from either the Constitution or legislation or both. It was submitted that Order 1, Rules 1 and 2 of the Constitutional Court Rules, Statutory Instrument number 37 of 2016, the rules, accords this court with requisite jurisdiction to reopen its decision by adopting the practice under Order 59/1/144 of the White Book to revisit its decisions that were rendered per incuriam. Petitioner's reply. In his reply, the petitioner referred the court to the case of Match Corporation Limited versus Development Bank of Zambia and Attorney General, in which the Supreme Court emphasized that the highest court has power to relook at its position on a point of law and to vacate it if that position is wrong. It was submitted that the principle of stare decisis is not an absolute rule. In the case at hand, it was argued that the court omitted, ignored, or forgot to apply important provisions of the law in its 3 previous judgments herein before referred to, and that on that basis, the court was not required to follow its reasoning in those decisions. It was the petitioner's further submission that Section 2 of the Act provides for the operative constitution, which was applicable on the date on which the 2016 amendment to the Constitution came into effect. That the reading of the Act, and in particular Section 2, leads to the conclusion that only the repealed Article 35 of the Constitution could apply to the first respondent's presidential term during the transition period, and that the court in the Legal Resources Foundation judgment went outside of the written law to reach its own conclusion. Amicus Curiae's brief. Mr. John Sangwa, State Counsel, made an application to be admitted as a friend of the court pursuant to Section 12 of the Constitutional Court Act number 8 of 2016, which provides as follows. The court may allow a person with expertise in a particular matter which is before the court to appear as a friend of the court. Based on Mr. Sangwa's consistent involvement as an advocate and litigant in the first respondent's presidential eligibility litigation, he was admitted as amicus curiae, or friend of the court, on 24th September 2024. He subsequently filed his brief on 25th September 2024. In his brief, Mr. Sangwa, State Counsel, submitted that the Constitution has not conferred this court with the jurisdiction to interrogate the eligibility of a losing presidential candidate to take part in the election post-election. He argued that what exists is authority to establish one's eligibility to take part in the election before the election is held. Further, he argued that if the court decides that it has authority to entertain this petition, that authority was circumscribed by Article 118 of the Constitution, which provides for principles of judicial authority. He submitted that the import of this provision is, firstly, that the exercise of the power must result in accountability and not anarchy. That therefore, where the converse will be the outcome, the court must decline to exercise its authority. It was further submitted in the exercise it was further submitted that in the exercise of its adjudicative authority, this court must protect and promote the national values and principles set out in Article 8 of the Constitution. It was argued that Article 118, Sub-Article 2F of the Constitution is reinforced by Article 9, Sub-Article 1A of the Constitution, which provides that the national values and principles shall apply to the interpretation of this Constitution. That it follows, therefore, that if the exercise of the court's authority will result in undermining the national values and principles, this court must decline to do so and dismiss the application. It was also argued that a declaration that the first respondent was not eligible to take part in the 2021 presidential election would have profound implications for the governance of this country. That its impact will affect the legality of the 2021 presidential election. That included the unqualified candidate, noting that a valid presidential election is one that involves qualified presidential candidates. Mr. Sangwa, State Counsel, further submitted that a decision of this court in favor of the petitioner will affect not only the first respondent, but all those who took part in the presidential election of 2021. He submitted that none of the remedies sought by the parties, by the petitioner, can be granted without this court hearing the persons that are likely to be affected by the said decisions. In this respect, he referred the court to the Supreme Court decision in the case of Max Mwamba and Stora Solomon Mbuzi versus the Attorney General of Zambia, in which the Supreme Court held that although the motion ostensibly questioned whether there was dignity and leadership in the exercise by the President of his constitutional power to appoint the two ministers, the blows were landing on two individuals who have never been heard and who stood to be condemned and heard and stripped of office. No court of justice can be called upon to make a declaration, which is always a discretionary remedy when obvious injustice would be visited upon persons who have not been heard but who would be directly affected by a declaratory order in proceedings to which they have not been made parties. It was then argued that similarly in this case, this court cannot entertain this petition and grant the relief sought without affording the presidential candidates in the 2021 presidential elections the opportunity to be joined and heard in support of or against the petition. Issues for determination. We have considered the petition herein with its accompanying affidavits, verifying facts, the respondents' answers and affidavits in opposition, the petitioner's reply, and the first respondent's affidavit in support of notice of motion for determination of questions of law, the second respondent and third respondent's affidavit in opposition to the first respondent's notice of motion for determination of questions of law, as well as the first respondent's reply. We have also considered the arguments, both written and oral, advanced by the parties. We have equally considered the brief filed by the amicus curiae, Mr. John Sangwa, State Counsel. We note that the parties in making their respective arguments, both in support of and against the petition, raised a number of issues. Arising from the relief sought, the main issues for determination as we see them are, number one, whether or not this court has jurisdiction to determine this petition. Number two, whether or not the first respondent was eligible to contest the August 2021 presidential elections in light of sections 2 and 7 of the Act, the repealed Article 35 and Article 106 of the Constitution. This relates to relief 1, 2, and 3. And number 3, whether or not the first respondent is eligible to contest future presidential elections. This relates to relief 4, 5, 6, 7, 8, and 9. Consideration and decision. We begin by restating the jurisdiction of this court as provided for in Article 128 of the Constitution as follows. Subject to Article 28, the Constitutional Court has original and final jurisdiction to hear A, a matter relating to the interpretation of this Constitution, B, a matter relating to a violation or contravention of this Constitution, C, a matter relating to the President, Vice President, or election of a President, D, appeals relating to election of members of Parliament and councillors, and E, whether or not a matter falls within the jurisdiction of the Constitutional Court. 2, subject to Article 28(2), where a question relating to this Constitution arises in a court, the person presiding in that court shall refer the question to the Constitutional Court. 128(3), subject to Article 28, a person who alleges that A, an act of Parliament or statutory instrument, B, an action, measure, or decision taken under law, or C, an act, omission, measure, or decision by a person or an authority contravenes this constitution may petition the Constitutional Court for redress. 128.4, a decision of the Constitutional Court is not appealable to the Supreme Court. The petitioner alleges that the first respondent and second respondent contravened the Constitution when the first respondent participated and was allowed to participate in the 12th August 2021 presidential elections, respectively. He also seeks interpretation of the Constitution as to whether Sections 2 and 7 of the Act had the effect of saving the repealed Article 35 of the Constitution and whether Article 106 can be applied retrospectively. As is our practice, we shall begin with the interpretation approach. Article 267, Sub-Article 1 of the Constitution gives clear guidance on how the Constitution must be interpreted. That is, in accordance with the Bill of Rights and in a manner that promotes its purposes, values, and principles, permits the development of the law, and contributes to good governance. In the case of Zambia National Commercial Bank PLC versus Martin Sonda and 58 others, we held that when interpreting the Constitution, all the relevant provisions bearing on the subject for interpretation should be considered together as a whole in order to effect the objective of the Constitution. In determining issues in this matter, we will therefore look at the relevant provisions bearing on the issues in contention as a whole in order to give effect to the objectives of the Constitution. Whether this court can depart from its previous decisions. The issues and arguments raised by the parties have invariably compelled us to consider the question whether this court can depart from its previous decisions. It was submitted by the petitioner that there are instances in which the court may forget or omit a statutory provision or point of law when rendering judgment. That in such circumstances the court has the power to correct these errors through the principle of per incuriam. The third respondent supported the petitioner's position on this issue and further submitted that the doctrine of per incuriam is an exception to the legal principle of stare decisis. It was also submitted that this court, being the apex court in constitutional matters, has jurisdiction to review and overrule its previous decisions. The first respondent, on the other hand, submitted that this court has stated its position on his eligibility to contest the presidency on 3 occasions. It was further argued that the mode of reopening the matter for the court to review its decision was wrong, and that the court therefore has no jurisdiction to entertain this petition. The second respondent did not make any submissions on this issue. To address the issue, we begin with the doctrine of precedence, often expressed by the Latin maxim, stare decisis et non queta mover, that is, to stand by decisions and not disturb settled matters, which requires that a legal principle that has been established by a superior court must be followed in other similar cases by that court and other courts. It should be noted that a court departing from its previous decision is a different legal concept from a court reviewing its own decision. The former refers to a court taking a different position in another different matter, while the latter refers to a court reviewing its position in the same matter. In the case at hand, the court is being asked to depart from its previous decisions. In order for us to adequately address the issue of whether this court can depart from its previous decisions, it is helpful to do a comparative analysis with other jurisdictions and also consider the position in Zambia before 2016 amendments to the Constitution. Apex courts in Africa, the Commonwealth, and beyond have had to confront the issue regarding their jurisdiction on departing from previous decisions. Persuasive insights are deducible from various court decisions from other jurisdictions, as well as ours, regarding this question. We therefore now proceed to recite some of these decisions in an endeavor to determine the position of this court on the issue. Number one, the South African position. The South African Constitution provides under Section 173 that the Constitutional Court, Supreme Court, Court of Appeal, and High Courts have the inherent power to protect and regulate their own process and to develop the common law, taking into account the interests of justice. In the case of Camps Bay Ratepayers and Residents Association and PS Booksellers Private Limited versus Gerda, Yvonne Eda Harrison, and Municipality of the City of Cape Town, the Constitutional Court stated that this argument raises issues concerning the principle that finds application in the Latin maxim of stare decisis, in brackets, to stand by decisions previously taken, or the doctrine of precedent. Considerations underlying the doctrine were formulated extensively by Harlow and Kahn. What it boils down to, according to the authors, is certainty, predictability, reliability, equality, uniformity, convenience. These are the principal advantages to be gained by a legal system from the principle of stare decisis. Observance of the doctrine has been insisted upon both by this court and the Supreme Court of Appeal, and I believe rightly so. The doctrine of precedent not only binds lower courts, but also binds courts of final jurisdiction to their own decisions. These courts can depart from a previous decision of their own only when satisfied that the decision is clearly wrong. Further, and in the case of Willie Jackson Ngaba versus Minister for Safety and Security and 4 others, the Constitutional Court of South Africa stated as follows. The doctrine imposes a general obligation on a court to follow legal rulings in previous decisions. Moseneke J. acknowledged the recognized exceptions to the stare decisis, namely where the court is satisfied that its previous decision was wrong, or where the point was not argued, or where the issue is in some legitimate manner distinguishable. A higher court of appeal, and this court in particular, has to be especially cautious as far as adherence to or deviation from its previous decisions is concerned. It is the upper guardian of the letter, spirit, and values of the Constitution. This court must not easily and without coherent and compelling reason deviate from its own previous decisions or be seen to have done so. One exceptional instance where this principle may be invoked is when this court's earlier decisions have given rise to controversy or uncertainty. 2, the Nigerian position. In Nigeria, there is no constitutional provision which expressly vests the Supreme Court with powers to review and depart from its own decisions. Article 235 of the Constitution of the Federal Republic of Nigeria provides that, without prejudice to the powers of the President or the Governor of a state, with respect to prerogative of mercy, no appeal shall lie to any other body or person from any determination of the Supreme Court. However, and notwithstanding the express prohibition, in the case of Amalgamated Trustees Limited versus Associated Discount House Limited, the court made the following pronouncement. The Supreme Court, as is the practice in other superior courts of record, possesses inherent power to set aside its judgment in appropriate cases. Such cases are as follows. 1, when a judgment is obtained by fraud or deceit. 2, when the judgment is a nullity, such as when the court itself was not competent. 3, when the court was misled into giving judgment under a mistaken belief that the parties had consented to it. 4, when judgment was given in the absence of jurisdiction or where the procedure adopted was such as to deprive the decision or judgment of the character of a legitimate adjudication. 3, the Kenyan position. Article 163, Subarticle 7 of the Kenyan Constitution provides that all courts other than the Supreme Court are bound by decisions of the Supreme Court. In the case of Frederick Otieno Outa versus Jared Odoyo Okello and 3 others, the Supreme Court in its ruling had this to say concerning the said provision. It is clear to us that Article 163, Subarticle 7of the Constitution can only be It is clear to us that Article 163, Sub-Article 7 of the Constitution can only be in effect, would entail the court divesting itself of powers that flow from its standing. Judicata is defined on page 1504 of Black's Law Dictionary, 10th edition by Brian A. Gunner, thus: Latin, a thing adjudicated. 1. Any issue that has been definitively settled by judicial decision. 2. An affirmative defense barring the same parties from litigating a second lawsuit on the same claim or any other claim arising from the same transaction or series of transactions, and that could have been but was not raised in the first suit. The 3 essential elements are: 1. An earlier decision on the issue. 2. A final judgment on the merits. And 3. The involvement of the same parties or parties in privity with the original parties. The doctrine of res judicata is, however, not an absolute principle, and there are several exceptions, including: 1. Lack of jurisdiction. 2. Presence of fraud or collusion. 3. Material changes in the law or facts. And 4. Mistake or per incuriam. Comparative jurisprudence also shows that the doctrine is not absolute. In the English case of Fidelitas Shipping, Lord Denning, Master of Rolls as he then was, said, "The rule then is that once an issue has been raised and distinctly determined between the parties, then as a general rule, neither party can be allowed to fight that issue all over again. The same issue cannot be raised by either of them again in the same or subsequent proceedings, except in special circumstances." The Constitutional Court of South Africa, in the case of Molaudzi versus S, also affirmed the development away from the strict application of common law of res judicata, and stated as follows: "Since res judicata is a common law principle, it follows that this court may develop or relax the doctrine if the interests of justice so demand. Whether it is in the interest of justice to develop the common law or the procedural rules of a court must be determined on a case-by-case basis. Section 173 of the Constitution does not limit this power. It does, however, stipulate that the power must be exercised with due regard to the interest of justice. Courts should not impose inflexible requirements for the application of the section. Rigidity has no place in the operation of court procedures." The court further held that it could depart from the doctrine of res judicata where the case at hand demonstrated exceptional circumstances that cry out for flexibility on the part of the court. It is trite that where the doctrine of res judicata is sought to be relied upon as a defense, the purpose of the principle is to balance the public interest in finality of litigation with the public interest of ensuring a just result on the merits. In light of the foregoing authorities, we are of the firm view that the doctrine of res judicata is not an absolute principle. It is subject to exceptions, which are relevant to the present petition, as shall be determined in due course, include circumstances where the previous decision was made per incuriam. Whether the first respondent was eligible to contest the August 2021 presidential elections. In his submissions, the first respondent urged the court to uphold its previous decision in the Legal Resources Foundation case that he was eligible to contest the 2021 elections. It was further argued that this petition is incompetent, as in essence it seeks to challenge the nomination of the first respondent outside the time frame prescribed in Article 52 of the Constitution. On their part, the petitioner and the third respondent submitted that the court interprets the combined meaning of sections 2 and 7 of the Act, as well as the repealed Article 35 of the Constitution, and urged the court to find that the inclusion of the first respondent on the 2021 presidential ballot was unconstitutional. The second respondent did not submit on this issue. We have taken into account the varying positions taken by the parties on this issue. In the Legal Resources Foundation case, in which the first respondent's eligibility to contest the 12th August 2021 elections was challenged, we stated as follows on pages J77 and J78. We find that Article 1063 of the Constitution does not bar the first respondent from contesting the forthcoming presidential election scheduled for 12th August 2021. For that reason, we hold that the first respondent's nomination, which was accepted by the returning officer on 17th May 2021, is valid, and that the first respondent, Edgar Chagwa Lungu, is qualified and entitled to stand for election as president on 12th August 2021. At the time of the holding of the 2021 elections, our decision in the Legal Resources Foundation case was binding, thereby enabling the first respondent to stand for election as president on 12th August 2021. This we affirm against the backdrop of the well-settled principle that court decisions and orders are binding and must be obeyed unless set aside or expire due to a fraction of time. This is the view we took in the case of Bernard Kanengo versus the Attorney General and the Electoral Commission of Zambia. Therein, we held that we wish to state that the Court of Appeal does not have jurisdiction to hear appeals to cases whatsoever dealing with Article 52(4) of the Constitution. Nevertheless, that stay order it had issued had to be obeyed, even though erroneously issued, and remains in force until discharged or set aside. The declaratory reliefs 1, 2, and 3 sought by the petitioner, urging this court to declare that the Electoral Commission of Zambia's inclusion of Edgar Chagwa Lungu on the 2021 ballot and his participation in the August 2021 election unconstitutional are therefore hereby dismissed. Amicus curiae. We now wish to refer to the brief filed by the friend of court, Mr. Sangwa, State Counsel. A review of his filed brief reveals that the gist of Mr. Sangwa's submission is that there is no provision in the Constitution that vests authority in this court to interrogate eligibility of a losing presidential candidate to take part in the election, post-election, which he has lost. He further submitted that a decision of the court in favor of the petitioner in that respect will not only affect the first respondent, but all those who took part in the 2021 elections without the court hearing them. Further, that it would also question the legality of the 2021 presidential election that included an unqualified candidate. However, and in view of our finding that the first respondent was cleared to stand for election as president in accordance with the decision of this court, Mr. Sangwa's submissions and arguments are of no consequence. Whether the first respondent is eligible to participate in any future presidential elections. In his submissions, the petitioner submitted that the first respondent does not qualify to participate in any future elections under the Constitution. This, he argued, is due to the fact that he has served 2 full terms and will therefore be in violation of the Constitution if he attempted to seek a 3rd term. It was submitted that the first respondent participated and won a presidential election in 2015, which culminated into his 1st term under the repealed Article 35 of the Constitution. Further, that for the 2nd term, he was elected under the Constitution as amended in 2016, and that this Constitution does not apply to his first term, as it has no retrospective effect. The court was urged to depart from its decision in the Legal Resources Foundation case, as it had completely omitted to take into account the provisions of Section 2 of the Act and was therefore per incuriam. The first respondent, however, submitted that the majority decision in the Legal Resources Foundation case comprehensively dealt with his status, that the said decision upheld the decision in the Daniel Pule case, in which it was held that the first term cannot be considered as a full term for purpose of Article 106, sub-Article 3 of the Constitution, and that therefore Article 106 of the Constitution did not bar the first respondent from contesting the August 12, 2021 election, and by extension, future elections. It was also submitted by the first respondent that the Legal Resources case was not per incuriam, as the dissenting judgment made reference to Section 2 of the Act, which meant that the judges were aware of this provision. It was further argued that this petition was wrongly before this court, as it had come by way of an as it had not come by way of an appropriate motion for review of the court's earlier decision. The court was called upon to uphold its earlier decision in the Legal Resources Foundation case. The first respondent is urging us to uphold our decision in that case, as the decision was correct and binding. In its submissions, the second respondent relied entirely on the answer, affidavit in support, and skeleton arguments filed on 16th November 2023. In his submissions, the third respondent submitted that the Legal Resources Foundation case did not pay particular attention to, nor did it take into consideration, Section 2 of the Act. It was further submitted that there was no need to provide for transitional provision in Section 7 of the Act, as the issue at hand was catered for in Section 2 by the definition of which constitutional provision applied on the effective date. Further, that the repealed Article 35 of the Constitution was clear in speaking to twice elected and not holding office. That the first respondent was therefore deemed to have twice held office and was barred from participating in any future elections. It was also submitted that ultimately, whether the issue has been pleaded or not, the court is being called upon to invoke the per incuriam rule. This court, in its majority decision in the Legal Resources Foundation case, asked itself a question as to whether framers of the Constitution in the transitional provisions under the 2016 constitutional amendments made provision for what was to happen to the incumbent president's term of office, which according to the court straddled two constitutional regimes. The court then looked at the provisions of Section 7.1 of the Act and came to the conclusion that the said provision shows that although the Act provided for the continuation of the President in the office of President, it made no provision for how the period served from January 2015 to September 2016 was to be treated in view of the change in the constitutional provisions from the limitation based on being twice elected to holding office for 2 terms. The court then proceeded to draw inferences on what the framers of the Constitution must have intended, and based on the provisions of Article 106 of the Constitution, concluded that Article 106, sub-Article 6 of the Constitution, regarding the full term, must be applied to defining what is meant by twice held office in Article 106.3 in interpreting the provisions of that article. Based on the above, the court then proceeded to conclude that the term served by the first respondent from 25th January 2015 to 13th September 2016 was an inherited term and not a full term as defined by Article 106, Subarticle 6 of the Constitution. Consequently, it was held that Article 106, Subarticle 3 of the Constitution did not bar the first respondent from contesting the 12th August 2021 elections. We have carefully considered the arguments by all parties in this petition. First, we wish to correct the misconceived view suggested by the first respondent that this matter is an application for review. To the contrary, our firm view is that the petition is beseeching us to depart from or overrule our previous decision in the Legal Resources Foundation case, as it was arrived at per incuriam. We note further that in that decision, there was no reference to Section 2 of the Act throughout the majority judgment, and a combined interpretation of Section 2 and 7 of the Act, read together with the repealed Article 35 of the Constitution, was never made. It is not in dispute that the first respondent was elected and sworn into office of President on 25th January 2015 under the repealed Article 35 of the Constitution. With regard to term limits, the repealed Article 35, 1 and 2 of the Constitution provided that Article 35, 1, subject to clauses 2 and 4, every president shall hold office for a period of 5 years. Article 35, 2, notwithstanding anything to the contrary contained in this Constitution or any other law, a person who has twice been elected as president shall not be eligible for re-election to that office. In 2016, the Constitution was again amended. The question, therefore, is, with the coming into effect of the 2016 amendments, what happened to the office of the President since his term was continuing up to September 2016? The answer to this question lies in the preamble to the Act, which states, "An Act to provide for the printing and publication of the Constitution, to provide for the savings and transitional provisions of existing state organs, state institutions, administrations, offices, institutions, and laws." From the wording of the above provision, it is clear that framers of the 2016 amendments had in mind transitional provisions or clauses to guide the administration of state affairs, including those relating to state organs, including the office of the President, so as not to create a vacuum. With regard to the office of the President, Section 7.1 of the Act provides that the President shall continue to serve as President for the unexpired term of that office as specified by the Constitution in accordance with the Constitution. The question that arises from the above provision is, which Constitution does Section 7.1 refer to? The answer to this question is to be found in Section 2.1 of the Act, which inter alia provides as follows. Constitution means the Constitution of Zambia 1991, in force immediately before the effective date. Effective date means the date of commencement of this Act and the Constitution as amended, as provided in Section 4. From the above provisions, it is our considered view that quite clearly the first respondent's first term, which ran from 2015 to 2016, was served by the transitional clauses and in particular sections 2 and 7 of the Act, and continued with the repealed Article 35 of the Constitution. In terms of the term limits, the repealed Article 35 was therefore applicable to his first term. Article 106 of the Constitution did not apply in retrospect, contrary to the holding in the Legal Resources Foundation case. The decision, therefore, is per incuriam. We accordingly depart and vacate that decision and previous decisions which made similar findings contrary to the well-settled principles of the law, that the law does not operate in retrospect unless it expressly states so. There is no provision that provides for the retrospective application of Article 106 of the Constitution. As we clearly stated in the case of Lucas Hamatowe and others versus Zambia Postal Services Corporation, when we said, it is trite that the law does not operate retrospectively unless there is a specific provision providing for the retrospective effect of the law. And there is abundant case law on this principle in this jurisdiction. Further, we said in the case of Lucky Mutambo versus Attorney General that if this court was to grant the petitioner's wish, it would be retrospectively applying the provisions of the Constitution as amended and reasonably, without any lawful purposes, without any lawful basis, and ignoring the provisions of the Act number 1 of 2016. It is our conclusion that prayers A and B must fail. They are accordingly dismissed. Having considered the provisions of Section 2 and 7 of Act number 1 and the repealed Article 35 of the Constitution, we take the view that the decisions in Daniel Pule, Pampika Palace, and Legal Resources Foundation were arrived at per incuriam, as Sections 2 and 7 are clear that the first term that ran from 25th January 2015 to 13th September 2016 was captured by the repealed Article 35 of the Constitution. For this reason, we further dismiss the first respondent's argument that the question of his eligibility to contest the 2021 elections, and therefore this petition, is res judicata. As earlier guided, a matter cannot be res judicata, where a previous case was decided per incuriam. On the same footing, this petition cannot be said to be res judicata. For this reason, reliefs 4, 5, 6, 7, 8, and 9 have merit and are hereby granted. Before we leave this matter, we feel compelled in the public interest and as a guardian of the Constitution to put to rest a fundamental misconception about Article 106 of the Constitution. The matter before us was premised on the assumption that Article 106, Sub-Article 6 of the Constitution qualifies Article 106, Sub-Article 3, thereby enabling a person who takes up a prematurely vacated presidential term of office to vie for and serve a further 2 terms in office. This assumption that there is, in inverted commas, a 3rd term in Article 106, Sub-Article 6, has been the source of much public tension and uncertainty, hence the need for our intervention. In a bid to address the issue, the third respondent submitted extensively on the principle of mandatory alternation as the source of Article 106, Sub-Article 3 of the Constitution and its antecedent, the repealed Article 35 of the Constitution. He contended that there was a contradiction between Article 106.3 and Article 106.6 of the Constitution, which ought to be reconciled or harmonized by ranking the 2 provisions. The third respondent contended that Article 106, Article 3, is the hallmark of mandatory alternation. With that in mind, we perused the first and final draft reports of the Technical Committee on Drafting the Zambian Constitution, TCDZC. The first draft report contains draft Article 103, which provides as follows. 1. The term of office for a president shall be 5 years. 2. Subject to clauses 3 and 4, a president shall hold office for 1 term, commencing from the date the president-elect is sworn into office, and ending on the date the election results are announced, and shall be eligible to be elected as president for a 2nd term. 3. Notwithstanding anything in this constitution or any other law, a person who has twice been elected as president shall not be eligible for election as president. 4. The president may in writing, signed personally and addressed to the Speaker of the National Assembly, resign from office. In the words of the TCDZC, the rationale for the article was that it was important to limit the number of terms to be served by a president in line with the current constitution, to avoid the tendency of an individual wanting to be in office in perpetuity. The committee therefore resolved to retain the provision in the current constitution. The final report of the TCDZC shows at pages 285 and 286 that as president. 4. The office of president becomes vacant if the president A. dies, B. resigns by notice in writing to the Speaker of the National Assembly, or C. otherwise ceases to hold office under Article 81, 107, or 108. 5. When a vacancy occurs in the office of the president, except under Article 81, A. the vice president shall immediately assume the office of president, or B. if the vice president is unable for a reason to assume the office of president, the Speaker shall perform the executive functions except the power to 1. make an appointment, 2. dissolve the National Assembly, and a presidential election shall be held within 60 days after the occurrence of the vacancy. 6. If the vice president assumes the office of president in accordance with clause 5A, or a person is elected to the office of president as a result of an election held in accordance with clause 5B, the vice president or the president-elect shall serve for an expired term of office and be deemed for the purpose of clause 3A to have served a full term as president if at the date on which the president assumed office at least 3 years remain before the date of the next general election, or B. not to have served a term of office as president if at the date on which the president assumed office less than 3 years remain before the date of the next general election. Article 1063 of the Constitution, when read with Article 106, Article 6 of the Constitution, provides that a person may or may not be deemed to have served a full inherited term. In common parlance, deeming relates to viewing or perceiving something in a contrived way. More formally, Black's Law Dictionary, 9th edition, gives as a main definition of the verb deem to treat something as if 1, it were really something else, and 2, it had qualities that it does not have. Hence, deeming allows an inherited term to count or not, depending on the length of time served. In our considered view, a contradiction between the two subclauses arises if the objective of the deeming is to enable the person who served an inherited term to contest more than one future presidential election, as it would create an exception. We have considered the issue on the basis of well-settled principle that constitutional provisions should be interpreted in a manner that harmonizes them. An exception to the clear prohibition in Article 106, Sub-Article 3, would have to be explicit and cannot be imputed from the language of deeming, especially in the face of the people's expressed commitment to a maximum of 2 terms. Hence, the deeming can only be consequential as opposed to empowering or permissive. We are of the firm view that the words "be deemed for the purpose" are intended to settle post-presidential questions about the legal status and the entitlements of a former president, as opposed to providing for a person's eligibility to return to the presidency beyond the mandated 2 terms. On a holistic reading of Articles 1, 5, 8, 9, 118, and 267 of the Constitution, with Article 106 of the Constitution, we find that Article 106, Sub-Article 6 of the Constitution, does not create a 3rd term. Final orders. Our combined interpretation, therefore, of Sections 2 and 7 of the Act and the repealed Article 35 of the Constitution is that the first respondent's term of office, that ran from 25th January 2015 to 13th September 2016, constituted a term of office. The first respondent's term, which ran from 13th September 2016 to August 2021, constituted his 2nd term. The first respondent, Mr. Edgar Chagwa Lungu, has therefore been twice elected and has twice held office. Article 106(3) of the Constitution makes the first respondent ineligible to participate in any future elections as a presidential candidate. Our finding in paragraph 833 above does not affect the first respondent's participation in the August 2021 presidential elections. For this reason, we do not find merit in relief 1, 2, and 3, and they are considered and they are accordingly dismissed. Reliefs 4, 5, 6, 8, 7, and 9 have merit and are hereby granted. In light of the significant constitutional issues that have been raised in this matter, we order the parties to bear their own costs.
Much obliged. We're most obliged.
This brings us to the end of today's sitting. We enjoin all those present in court to maintain silence until the court has risen.
Court rise. That's memory to give him another one. Like he deserved water.
So we still live from the ConCourt, where the ConCourt judges are just from delivering the judgment regarding the issue to do with the eligibility case of the former president in Mr. Edgar Chagwa Lungu. Darius, we have been informed by the judges that indeed Mr. Lungu was eligible to contest the 2021 general election, but for any future elections he is ineligible.
That's the interpretation of 7 constitutional court judges that presided over this matter. A petition that was taken by a youth activist, Mijelo Jizombe, was challenging the eligibility of the former president to contest the 2021 as well as future election. What has come out so interesting in Chimunya is the pronouncement of the judges that the former president was eligible to contest the 2021 general election, and they hold, a view that was held in the previous judgments that were, delivered. The judgments in the Shishua as well as Chapter 1 Foundation. But they have departed from the decisions that they made, citing certain sections of the Constitution, and they've come out with an interpretation that the former president has already held office twice, from 2015 to 2016 being his first term into office, and from 2016 to 2021 being his second term into office, and therefore is barred to contest any future elections, and that's for the avoidance of doubt. So this is a settled matter, but like we said, even the other time, a similar judgment was delivered, one that had allowed him to contest the 2021 general election. The question that is being asked now is, are we likely to see another petition? Well, we'll wait and see what will come out next. But one thing for sure is that the Constitutional Court has declared the former president not eligible to contest the 2026 election.
Indeed, Darius, let me just get to engage Councillor Clement Andelek just basically on what he makes of this judgment. Councillor, you've been in the courts listening to the judgment that was made by the Constitutional Court judges. What's your take?
I think this is a historical judgment. I think it's a novel judgment, meaning it is brought up very new arguments. It has straightened the areas which were considered to be grey areas in the Constitution. As you are aware, the issues that generally arose was whether Edgar Lungu had held office or not, in accordance with the provision and the interpretation as attached in the provisions of Article 106. Article 106 deals with the issue of holding office. So the Constitutional Court today has pronounced itself in this historical judgment. I think it's a very well-reasoned judgment. It has settled major points of law, and I think it brings a lot of satisfaction in the legal fraternity. This is a very good judgment, I think, for today, tomorrow, and the future. So we are so happy in the legal fraternity that the court has pronounced itself in that manner.
Council, we've seen this is a case that has been coming back and forth. From your own analysis, overview, do you think maybe there could be another petition coming from any stakeholder?
Petitions, anyone is free to approach this court. The reason for the Constitutional Court is to interpret the Constitution. I think any Zambian who has listened or who have an opportunity to read this judgment would not even petition. The issue about holding office, you know that from 1991, no president can hold office beyond 10 years. Edgar Lungu served for for 7 years, and you're seeking to save another 5 years to make 12 years. It is illegal. Even in common sense, it does not make sense. The issue in the Constitution is well addressed, particularly when you read Article 1062. It deals with the issue of holding office. And the period of holding office is clearly stated in Article 106, sub-article 2. It says holding office means from the date the president-elect has been elected to the time the next president-elect is sworn in. So was Edgar Lungu elected? Yes, he was elected. Common sense in 2015. In 2016,